Hello, everyone, and welcome to this Federalist Society virtual event. My name is Sarah Clark, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc forum called SpaceX v. NLRB, a new chapter for labor law. We're very pleased to welcome Professor Ann LaFazzo and Aaron Solom as our excellence panelists for this discussion. Professor LaFazzo is a professor of law at the University of Cincinnati College of Law, where she teaches labor law, employment discrimination law, and constitutional law. Aaron Solom is a staff attorney at the National Right to Work Legal Defense Foundation, where he represents both private and public sector employees in state and federal courts, as well as before administrative agencies. And special thanks to our moderator, Patrick Pizzella, who recently served as Deputy Secretary of the U.S. Department of Labor from 2018 to 2021. President Donald Trump nominated him to serve as Deputy Secretary, and the U.S. Senate confirmed Pizzella on April 12, 2018. In 2023, he was elected to a 4-year term as the mayor of Pinehurst, North Carolina. If you would like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we will turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I will note, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Mr. Pizzella, thank you so much for joining us today, and I'll hand things over to you.
Thank you. Welcome, everybody. I first want to put a rest to the rumor that the only reason I was asked to be the moderator is that Elon Musk declined the Federalist Society invitation. So let me turn things over to Aaron, who will describe the situation that we're in at this moment on this case.
Thank you, Pat, and thank you, the Federalist Society, for having me, and for Professor LaFazzo for agreeing to be here today. So for the past 3 to 4 years, the NLRB, along with various other federal agencies, have been sued by private parties based on claims that those agencies' officers' removal protections violate Article 2 of the Constitution, namely the vesting and take care clauses. Article 2 vests all of the executive power in the president, and it also requires him to take care that the laws be faithfully executed. When there are officials in the executive branch that exercise executive power, but are not subject to the president's direction, it removes the executive power from the president and his ability to take care that the law be faithfully executed. These are exciting constitutional issues, but they really aren't new. We've been debating these issues since literally the first Congress, where they debated whether they had the power to restrict the president's removal of certain officers. And removal issues were a major issue 100 years ago, which culminated in the Supreme Court's decision in Myers and Humphrey's Executor. So we're going to be talking about the Fifth Circuit's decision today in SpaceX v. NLRB, and it is a major decision because it's the first appellate court to recently squarely hold that citizens have a right to preliminary and joint administrative actions until questions about the removal restriction of those officers they're appearing before are resolved. However, I do think there's a lot of misunderstanding about what the ultimate effect of this litigation will have on the NLRB. Ultimately, it's not going to change much of the day-to-day enforcement of the act, and it will probably matter more for how quickly a new administration can take control of the agency. But to back up a bit to describe the agency for those who aren't familiar with it, the NLRB is a federal agency that's responsible for enforcing the National Labor Relations Act. It covers most of the private sector, and it's a bifurcated agency. So on one side, you have a general counsel, who's a principal officer appointed by the president and can be removed by the president for any reason. And they're responsible for bringing all unfair labor practice claims before the board. The NLRA, on the other side, you have the 5-member board, whose job it is to adjudicate unfair labor practice cases. But the board also has other duties. It can seek injunctions in federal court. It can ask a federal court to enforce its decisions. It conducts elections, and it also issues regulations. But most importantly for this case, for our discussion, the board also hires and oversees its ALJs. Now, unlike the general counsel, board members can only be removed under the statute for neglect of duty or malfeasance in office. And the board can only remove its ALJs for good cause. And that removal is also subject to the approval of another federal agency, the Merit Service Protection Board, whose members are also only removable for a good cause. So when it comes to ALJs, they arguably have 3 layers of for-cause protection. So that brings us to this case. SpaceX was being prosecuted by the general counsel for violations of the National Labor Relations Act, and it turned around and sued the NLRB in Texas federal court over the NLRB's ALJ and board member removal protections. Now, there was actually 2 other structural claims dealing with the right to a jury trial and the 7th Amendment and some due process blending of function claims, but the Fifth Circuit didn't address those claims, so we aren't going to discuss those today. But SpaceX sought a preliminary injunction to halt NLRB proceedings until their claims and request for a declaration that these officials should be subject to at-will removal could be litigated. Eventually, the district court enjoined the ALJ proceedings against SpaceX, and the NLRB appealed. The NLRB made about 4 major arguments, really, before the Fifth Circuit. First, it claimed the court lacked jurisdiction under the Norris-LaGuardia Act. Second, it claimed that there was no likelihood of success because ALJ removal protections were constitutional. It also said that there was no likelihood of success for SpaceX because board member removal protections were constitutional. And then finally, it said SpaceX should have to show that they were actually prejudiced by these removal protections. In other words, they would have to show that but for these removal protections, the president would have wanted to or would have fired an ALJ or a board member. And the Fifth Circuit ruled overwhelmingly in SpaceX's favor on every single claim, and it rejected the NLRB's appeal. First, it found the Norris-LaGuardia Act was inapplicable. And for those who don't know, Norris-LaGuardia is a law that divests district courts of jurisdiction to issue injunctions over management disputes, except in very limited circumstances. It passed in the 1920s before the NLRA because Congress was worried about a growing number of strikes and union activities that were being enjoined by the federal courts. The law specifically says it applies in any case that arises out of a labor dispute. So the question is whether SpaceX's constitutional claims about removal grew out of a labor dispute. Well, in one sense, maybe it does. Because but for a labor dispute between SpaceX and its employees and the NLRB charges, SpaceX wouldn't have to be suing the NLRB. But the problem for the board's argument that the Fifth Circuit saw is that Norris-LaGuardia's definition of growing out of a labor dispute is far more narrow. The Norris-LaGuardia Act says a case grows out of a labor dispute when it involves persons who are engaged in the same industry, trade, craft, or occupation. And SpaceX isn't in the same industry as the NLRB. The NLRB is a federal agency. SpaceX makes, rocket ships. And a labor dispute itself is a controversy concerning the terms and conditions of employment. And obviously, the constitutional questions about removal protections are not the same thing as a dispute on the terms and conditions of employment. So that moves us then to the merits of SpaceX's claims. And the court found SpaceX had a likelihood of success on both of its removal claims. First, they found that ALJ protections are likely unconstitutional. In the Fifth, this is actually a relatively easy case because the court already struck down SEC ALJ tenure protections that have multiple layers in a case many of you may have heard of called Jarkizi versus SEC. And of course, this is working off of the Supreme Court's decision from about 15 years ago in Free Enterprise Fund, where they found inferior officers cannot be shielded by more than one layer of for-cause removal protections. Free Enterprise Fund, of course, dealt with the PCAOB, the Public Company Accounting Oversight Board. Third, and probably most controversially, the Supreme Court found that board member removal protections were unconstitutional. Now, this has been the subject of a lot of controversy because it goes to the continuing validity of Humphrey's executor, which of course is the kind of been the bête noire of the conservative legal movement for the past 100 years. In Humphreys, the Supreme Court found FDR's removal of William Humphrey from the FTC illegal, and they found that the president's power of removal could be restricted when you had a multi-member expert agency balanced along partisan lines that did not exercise the president's executive power. Here, the Fifth Circuit found that the NLRB failed this test, and it was not similar to the 1935 FTC because the board exercises executive power, and it's not balanced along partisan lines because nothing in the NLRA requires the president appoint members from different parties, whereas the FTC requires only a bare majority of one party. And so finally, the court ruled that there was no requirement for a party to show that the president would have fired a member of the board to secure an injunction. The board made this argument because a couple terms ago in Collins versus Yellen, the Supreme Court said an unconstitutional removal protection only voids the actions of an agency if a plaintiff can show the official would have been removed but for the tenure protection. The Fifth Circuit said Collins versus Yellen only applies retroactively. It only applies attempts to void an action of an official. Here, SpaceX hasn't appeared before an official who's acted yet. The ALJ hasn't decided their case. The board hadn't decided their case. So because they didn't act it, there was nothing to void. Rather, this was about an injunction to secure their ability to receive relief of not being forced to appear before someone who is not politically accountable. So what does this mean for the board? Well, in the short term, frankly, it means anybody appearing before the board in the Fifth Circuit is a good shot at securing a preliminary injunction that stops the case. But ultimately, that's going to be just a temporary pause while the merits of the case are being determined. And in the long term, there's a lot of hand-wringing about these cases. You know, I see a lot of commentary, it's going to end the NLRB. But that's not what's, at least in my mind, that's not what is going to happen. At most, these claims are going to make it so board members and ALJs are politically accountable because they'll be terminable at will. That's because in this instance, the remedy for unconstitutional removal protections is to sever those protections from the statute, to essentially cross them out, not strike down the entire statute. And that's what the court has done in some of its most recent removal cases, such as Free Enterprise Fund and Celia Law, where the court refused to strike down an entire statute in a regulatory scheme over removal protection, and instead said, no, we can just sever it from the statute and let the rest of the statute survive. As to the merits, the rest of it, I think this case or a similar one will eventually be decided by the Supreme Court. Obviously, there's the removal issues being litigated because President Trump fired a member of the National Labor Relations Board, Gwen Wilcox. That case is pending right now in the D.C. Circuit Court of Appeals. The Supreme Court put out an order that refused to reinstate her to office. So eventually this is going to be decided by the Supreme Court, but ultimately it's just going to make board members and ALJs politically accountable. Now, what does this change? In my mind, not that much, actually, because the board is already an agency that has a reputation for shifting a lot in the political winds. There's always policy oscillation between boards. Republican NLRB members overturn Democratic members president. Democratic members overturn Republican president. What this will change is not so much how the cases are decided, but when they're decided. Because if presidents can control the board at the beginning of their term by firing members, not waiting for members to fall off because members serve generally 5-year terms, it's going to speed up this policy oscillation. So a president's going to come in and they're going to clean house. Will a board fire an ALJ? Maybe. It depends. I think that's more unlikely, but you could imagine a few being fired in the future. That's all that's really going to change. I don't think the day-to-day enforcement of the act is going to change or anything else is really going to be affected by these cases. And so I think a lot of the hand-wringing over this is a little overstated. But
all right. Thank you, Aaron. We'll see if there's any hand-wringing or not. We'll ask the professor to shed some light from her view of things.
Well, first, I want to thank the Federalist Society and Pat and Aaron for inviting me and for being my co-debater here. I really appreciate the Federalist Society so much because, as I was telling everyone earlier before we started, it's so important to civilly debate things, especially important public policy issues. and to allow the public to make their own decision on these things by giving out facts and legal analysis rather than misinformation. And I want to say that I think Aaron did an incredible job explaining this case. And in some ways, there's very little we disagree on. But in the fundamentals, there are arguments I'm going to put forward right now that show where we disagree. First of all, I agree with everything he said about the Constitution, that Article 2, what's at stake is Article 2's vesting clause and its take care clause, and that this is about executive power. Also, this is about ultimately a political accountability, and that he also described that the agency is a bifurcated agency, and I think did an incredible job explaining in a very easy way. And I know some of my students are listening today, and please, I hope you paid attention to him. I'm also going to be assigning this to watch for everyone, so please pay attention to what he did because it was really, really great. And we aren't going to talk about the right to jury trials and due process, although that's a really interesting debate that we can have another time. Okay, so here we did have the injunction again that SpaceX was able to successfully get against the board, and the court. I'm going to start with each of these arguments and then explain why I think they are potentially wrong. I actually think they are wrong, but I also think that what my analysis of this is not necessarily likely to be successful at the Supreme Court, which I think is also important to understand is what I say today may not be how I would advise a client. So first, the court lacked jurisdiction under the Nassau-LaGuardia Act. And I would argue that with the board that it does. And that's because as Aaron said, it divests federal courts of jurisdiction, and it applies to any controversy that arises out of a labor dispute. Now, what the court did that was, I think, like a sleight of hand, really, but it makes some sense in a lot of ways, is saying this is not really a dispute arising out of a labor dispute. This is a controversy or a case or controversy that's arising between one party, the board, and this other party, an employer. Because what they're really saying is that the employer is that the NLRB is unconstitutional, and therefore that what the employer is doing is really disputing the constitutionality. Now, the problem with this, as also Aaron suggested as a possible argument, is that, and he didn't concede that, I'm just saying that we both acknowledge each other's arguments here, is that without this underlying dispute, you wouldn't be getting here. Okay, so in that sense, it's like saying here's this labor dispute, and these parties going to say you're unconstitutional, so we don't have to be subject to that. It kind of reminds me in a loosely analogous way of the way the Commerce Clause originally, or at least during the Lochner era, said, oh, it's only about buying and selling, and we narrowed the Commerce Clause to that. And then finally in the New Deal said, no, it's the whole stream of commerce. Here, it's like, let's just, I would say arbitrarily, but I think my on the other side, they would say it's not arbitrary, would say, this dispute is about the constitutional structure. There's a lot of force to that, and Aaron did a good job explaining that. I would say, though, that the problem with that is that then every single dispute can just go to court and on a constitutional question, and you can constantly enjoin the NLRB, which would really which potentially could grind the courts or the administrative agencies in general to a halt just by constantly claiming that it's a constitutional issue. However, that parade of horribles is not necessarily persuasive. And so another problem is that the agency is that, well, let me go on to the next one, and I'll get to that later, okay? So there's your Norris-LaGuardia, and the Norris-LaGuardia Act is also being very narrowly interpreted here. Aaron said that the other side's broadly interpreting it. That is true. I'm saying that his side is narrowly interpreting that. That's also true. The reason that I think my side has more persuasive force is because this is exactly what happened with why we got the Norris-LaGuardia Act in the first place, is because the Supreme Court started narrowly interpreting the Clayton Act. The point of the Norris-LaGuardia was to remove federal jurisdiction from the courts. And then later on, what the Congress did was to say, hey, we have a way to test the constitutionality of the act. And it's not through injunctions, it's through this process called unfair labor practice cases. And in fact, that's how the whole act was tested in 1937. It's exactly how Jones and Laughlin was done. So I can anticipate a response to that would be, well, they could have done it the other way. I don't think in 1937 that would have worked. So query whether now, because we're in a different political climate, that would work. So I want to make that's a really important part of my argument. Okay, the second one is about the likelihood of success on the merits. And that's really just about the removal protections for the board agents, the board members, sorry, and the ALJs. Okay, so just a couple of points here. That the court relies on, and all of these Aaron talked about, Myers v. the United States, where the president had unrestricted power to remove purely executive officers. So there's a lot of hurdles that have to be overcome to say that Myers applies here. And that's from 1926, by the way. First of all, it has to be executive officers. So why are we categorizing the NLRB members and ALJs as performing executive when they're really performing quasi-legislative and quasi-judicial functions, not really performing executive functions? This is a much easier hurdle for the ALJs to meet, because they're clearly adjudicating. For the board, I think that's going to be harder for my side, but I still think it works out there. Also, ALJs are inferior officers, and so therefore this may not apply at all to ALJs. And there has been the Supreme Court in I think it was Free Enterprise Fund actually said that it doesn't apply to these inferior officers. So that's another case that Aaron brought up about the dual layer removal protections violating separation of powers. The NLRB ALJs do have similar dual layer, actually, and as Aaron pointed out again, maybe even 3 layers of protection. But the court specifically said that multi-level removal protections are not per se unconstitutional, and you can always sever. So why didn't they just sever it? Why did they decide to allow it to go forward? The court has an unpersuasive argument for that, which I'm sure Aaron will talk about and give you a more persuasive reason for that. So then seal of law is another case that the court relies on. And seal of law is a single director agency with for-cause removal. And they said that was unconstitutional. But we know we don't have a single director agency here. The board is a multi-member board. It's also a bifurcated agency. It's not a single director agency. And so it's much closer to the model that was upheld in Humphrey's Executor. Now, Jarcasi, absolutely true. Jarcasi, in terms of the Fifth Circuit has mandatory in-circuit authority, so it had to go by its own decision in Jarcasi. So that it had to do unless it was going to overturn its decision in an en banc decision. But the problem here is that, again, that ALJs are inferior officers. They are allowed to have these protections, and therefore these should not be unconstitutional. Okay. Let's see, what did I miss? I guess the last one would be, hold on a second. Did I miss anything? If I did, I can pick it up after, either in questions or sir rebuttal. But I just want to make sure there's
maybe a discussion about Collins, whether or not you have to prove prejudice or causal harm.
Oh, yes, that's a really good point. This is an interesting argument. I think it's really a standing argument. I've been thinking about this, that so is constitutional harm itself good enough? I think that's a really good argument, actually. The counter argument, which is what I would argue, is that that the president hasn't tried to fire anyone for this. It's exactly what Aaron was saying, that the board had argued, is that the president doesn't seem to want to get rid of anyone for this. Now, it's very interesting at the end of Aaron's talk. I found this really interesting, is that, what's at stake here? So the board is very political. I agree with that. This policy absolutely has been criticized for that. So how much is this going to change? Because, and it's true that maybe the president should have the ability to fire right at the beginning. But this is where I'm concerned. Okay, let's say we allow that. But then in the middle of the term, the president decides he doesn't like a decision. So he's just going to take it away. And then we get even more instability. So this could really could destabilize the entire administrative agency. Now, the counter to that would be, well, this is what political accountability is. But one of the whole criticisms is this oscillation. And so, because the oscillation is creating instability, which is bad for business. I'm not sure it's going to be better for business to just have the president fire people, which he seems to. Let's face it, the president has been willing to fire federal employees. So those would be my my counter arguments for now, and I look forward to hearing his rebuttal, and also to the questions from the audience.
Aaron, do you have something you want to provide?
Yeah, I would just make a couple of great points to piggyback on what you were saying, what Professor LaFosse was saying. I think really the first argument against these removal restrictions that you brought up was, why are we treating these as executive officers when they perform sometimes what are called quasi-legislative and quasi-judicial functions? I mean, this was the reasoning of Humphrey's executor, which said members of the FTC can't be removed because they perform quasi-legislative and quasi-judicial functions. I think a lot of people have misunderstood what Humphrey's executor was talking about when they said quasi-legislative and quasi-judicial, because if you read Humphrey's executor, they're talking about the FTC's role in serving as kind of a clearinghouse for congressional investigations. And in fact, most of their functions at the time were meant to aid Congress and then serve as a master in chancery for district courts, which is different than we think of quasi-legislative and quasi-judicial functions today when we think of policymaking and judicial functions. But even putting that all to the side, this is an argument that the Supreme Court, the modern Supreme Court, starting even with Morrison itself, has rejected. There's no quasi-legislative and quasi-judicial functions in the executive branch. We have three branches of government. We have a legislative branch, and the legislative branch operates through Congress with bicameralism and presentment. We have a judicial branch, Article 3, and that's when judges who are protected by life tenure make laws. And then everyone who is in Article 2, which the NLRB is Article 2, exercises the executive power. And the fact that they perform adjudicatory functions doesn't necessarily save them, because adjudication, which an executive has done since the founding, since there's a long history of it in the English tradition of the executive performing adjudicative functions. And that's just simply applying law to facts. And even if they're dressing up and acting like they're judges acting like they are judges with robes and wigs, right? That doesn't change the fact that it is an executive power. And this is what the Supreme Court said starting in Morrison. It recently affirmed it in Free Enterprise Fund. And in Celia Law, they said the head of the Consumer Finance Protection Bureau performed adjudicatory functions, and that was a reason that at-will removal was required. So I think it's wrong to just say, well, the board performs this kind of function, and look at the board's functions, which are mostly adjudicatory, although they have other executive functions. They have prosecutorial powers, such as 10J, such as enforcing their own decisions in federal court. I think it's wrong to take those out and say, well, we're going to make an exception for this kind of executive action, because ultimately it is still the president's power in that situation. Professor LaFosse also said free enterprise fund exempted ALJs from its decision. That's a common misreading, I actually think, of free enterprise fund. There is a footnoted free enterprise fund that says, well, we don't know whether this applies to ALJs because there's a dispute whether ALJs are inferior officers. But guess what? A few years later in Lucia, the Supreme Court said ALJs are inferior officers. And then after that case dealt with SEC ALJs, and then the board itself in a later case, the NLRB said, oh yeah, our ALJs are definitely inferior officers too. You know, I think moving on to what Professor LaFaso said about Collins is I actually agree Collins should be thought of as a standing case because the only problem with that is the Supreme Court itself decided the merits, and then they said, well, we have to send it back to determine whether or not you receive this remedy. But the language they use is certainly one of standing when they talk about harm. The way the NLRB in all of this litigation has framed it, they framed it actually as a question on the merits. They've said it just becomes another merits question that you have to reach before you can even decide whether or not the unconstitutional tenure protection can be adjudicated. And then, you know, will this create more instability because the president will fire someone in the middle of the term? You could say that would create instability, but I think that would create more, I think that creates more accountability because ultimately the president is the one responsible for how his administration functions. And this is not a new question. In fact, Madison, during the debates in 1789, during the decision of 1789, said if the president makes the wanton removal of officers by the president, will himself become a cause for the president's removal. And so ultimately, the question is do we have a democracy where our elected officials are responsible and accountable to the voters for their own decisions, or can their power be exercised by those that they can't control? And considering the fact that we are a democracy and the framers wanted a government that was politically accountable, I think removal is a better option, as well as being the constitutional one.
Okay. Professor, anything you want to reply with?
I'll just reply with a big thought in that I agree that this creates accountability to the president, but it also further consolidates power in the executive. And the founders also wanted checks and balances, more balance and more checks. And I don't think they would have conceived of the president being this powerful, especially since it's the Article 2, not even the Article 1 branch, which is Congress. So perhaps we're not giving enough to Congress that carefully designed the administrative state so that it would have these checks and balances. So we're kind of getting rid of some due process in the name of accountability. But I do everything that Aaron is saying, I think makes a lot of sense.
All right, let me take a question we have from one of the viewers. Doesn't political accountability in this case arise from the voters in a presidential election? Or put another way, why should the courts exercise the executive power to remove its officers who can and have thwarted executive policies? Professor?
Well, yeah. I mean, there is, one thing you would say is that the executive branch is the most accountable. And the reason is the president is the only office that all the people vote for. With the little minor thing about the electoral college, but putting the electoral college aside, it's still the most accountable. And so why do we need this? And I think that's for Aaron to give his opinion on.
Aaron?
I think the question hits at the heart of it, and I just want to use a recent example that I thought of, right? So President Trump wins election in November 2024, right? He wins with, he won a majority of the votes, and he also wins in the Electoral College, right? Popular vote is not a real metric, but it says something maybe. So a month later, the Senate Senate Democrats and along with the Biden administration tried to jam NLRB members through that would have prevented President Trump from controlling the board until essentially his third year in office. And if you look at that and say, why does the dead hand of a presidential administration that lost get to control the labor policy? And the NLRB is the main, no offense to Pat and his work at the Department of Labor, but I think the NLRB is the major private sector labor policy driver in the federal government. And why does the dead hand of the past administration get to control and undo the results of the election? And I don't think there's a good answer for that. And so that's why the president has to have the ability to remove officers. And ultimately, what is the limiting principle, right? Is it okay as long as the president can control a so-called independent board in his third year? Would it be okay to stop him till his fourth year? What if he couldn't control at all? What if they were 10-year terms? Ultimately, there's no other limiting principle other than the fact that the president must have the ability to enforce the law and see that his constitutional executive power is not taken away from him.
Okay, let me go to another question we received. How do Branty v. Finkel and Rutan v. Republican Party of Illinois fit into this discussion? I'm assuming one of you two are familiar with this case.
I have no clue how
Okay.
I don't know.
Okay, and at this moment,
maybe you can explain it a little more.
At this moment,
maybe,
it does not fit in. It does not fit into this discussion at this moment. Let me go to another question we received. With the reading of Article 1 adjudicatory bodies, could the president overrule decisions and entirely replace the members of the bankruptcy and U.S. tax courts?
Okay. Okay. So bankruptcy courts have a different constitutional analysis, because if you look at the history before the founding, judges in England were allowed to use special masters in bankruptcy. And bankruptcy courts also have a specific structure that's different than other so-called Article 1 courts, because they all just essentially function as adjuncts to specific district courts, right? Tax court is a little different. So tax court is sometimes called a traditional Article 1 court. But like I said before, there's no such thing as an Article 1 court. Article 1 is about Congress, and Congress acts with bicameralism and presentment. Our so-called Article 1 court doesn't do that. The tax court is in reality an executive administrative agency, and I think the president has the authority to remove members of the tax court as long as they're exercising executive authority. And so you would have to look under the decisions like in Celia Law and Collins, and to see whether or not that their exercise of power and any for-cause removal protections that they have restrains his ability to see that the law be faithfully executed. But, calling something an Article 1 court is just a branding exercise. It doesn't determine the actual power that they exercise.
Okay.
I'll just add that I agree with Aaron's description of bankruptcy courts I'm by no means a bankruptcy or a tax expert, although I used to be a bankruptcy attorney when I was in my 20s, and they are really an adjunct of the district court, so they are very different. So I would say it's the analogy is much closer with the tax courts than it would be with the bankruptcy courts. So I agree. I also want to add that I think one of the interesting themes I'm hearing here is about that there's legislative function, executive function, and judicial functions. And I think that this is going to be a collision of different views of these functions. Some of us feel that these are very separate. And that's what I'm hearing a lot from Aaron right now. And others of us think that there is more of a murkiness between them. And so I think that the court probably is more in Aaron's camp right now. And in other times, it was more in my camp. and that we are in an era where there's separation of powers is very separate. So it's something important, I think, to keep in mind.
All right, let me
Can I
Go
just
ahead,
piggyback
Aaron.
off that real quick? I don't want to make any predictions because I don't want to be proven wrong later, right? And
Right.
pay for it. The court I would look back, especially on this question, and it just flagged in my mind, is the person who asked that, go read Justice Scalia's concurrence in Freitag, where he talks about how the tax court is actually an executive body. And I bet if you if you gave all the members of the court a truth serum and polled them, they probably agree with Justice Scalia's opinion in Freitag. And I think that kind of shows where this is going.
Okay. Let me go to another question. Absent a quorum, who can speak authoritatively for the NLRB as to its legal position with respect to the litigation if its legal position is contrary to the position taken by the Department of Justice on behalf of the Trump administration?
Okay, so I would say the general counsel, I was going to start because Aaron started the last one. I would say the general counsel has that authority. I don't think right now it is going to be contrary, but that has happened when I worked at the NLRB. I worked at the NLRB for 10 years. The NLRB and the Department of Justice can have contrary views on things. And the NLRB, as an independent agency, at least in the past, has been allowed to represent its contrary view and argue cases before the Supreme Court opposing the Department of Justice. Now, whether that would continue or not, I don't know. But I would say that the Department of the General Counsel can actually speak on this.
Really? Aaron?
So, that's a complicated question, I think, because if you look at the Constitution, one of the duties officers have is they can give their opinion in writing, right, to the president, right? The president may call for the opinion of his officers, and they have to give them in writing, right? And so does the whole of the executive branch need to speak with one voice in every occasion? Well, if the president says so, probably yes. But if the president doesn't say so, can the DOJ and NLRB have differing opinions in a case? Well, maybe. I don't know. But I think just you're correct, is that the general counsel would speak for their client, the board, and they would probably defend the board's order in that case until a new board issued a different order.
And I'll just add that it is very complicated because if the president it's not the president that's behind this litigation, but it's certainly his view, wins these types of cases, then I think everything I said, the general counsel could still speak, but it would be in unison because we would get a more powerful and more centralized executive authority, more unitary authority. But that hasn't always been true, and certainly not in my tenure. So again, we're really in interesting times right now.
Okay. All right, let me try another question. We have an active viewing audience there. The executive branch can only execute laws forwarded by the legislative branch. The executive doesn't get to make up laws. Removal of anyone on prohibition is in the contract. Removal without cause is okay. So why is there an argument of a president executing a law written by the legislative branch?
I would say that was a debate that we had in 1798, right? The first decision in Congress was whether or not Congress could restrict the president's power to remove. And they said, well, because it's the president's job to execute the law, we are not going to pass a law that restricts the ability of the president to remove at will, lest we take away his power. Because while Congress creates the office, the president is the one who executes it. And so it is his power. And by saying it must be for cause, it either gives us a veto, that is Congress, or it gives a judge a veto in Article 3, whether they determine it is good cause. So it disperses that power. And like Madison said, it removes accountability because suddenly nobody knows who to blame for this decision. The president can say, I'm not responsible for this decision. It was somebody that I didn't appoint and I can't even remove. Or if I did appoint them, I would remove them, but I can't. And so it takes away that accountability, which was important to the founders. That would be my argument. But that is I mean, like I said, we've been debating this since the founding.
Professor?
Yeah, I think what Aaron just said is about the best argument in favor of that. And that, on the other hand, I think what the questioner, it's the question I have also, is why aren't we really enforcing what Congress wanted, and if they wanted removal? Now, I think it's a good point that, well, then you have to take away that power. So maybe there is a way of, if the court goes in this direction that we think it may, that there's a way of restructuring administrative agencies so that the president doesn't have certain powers that are not given to it by Congress, and therefore it wouldn't be a matter of accountability, but that would be for Congress to decide after this case or other cases.
Okay. Listening to these questions and your responses, this case seems much bigger than just the labor management community, and bigger than the NLRB. So what are the secondary and tertiary effects of the outcome of this case, assuming it gets to the Supreme Court and they opine, that will spill over to the entire sort of administrative state that's been set up in the last 100 years or so? Who wants to go first there, Professor?
Aaron, do you want me to start?
Yeah, you go ahead.
It really depends on how they decide. So if they decide the way Aaron said was one way they could decide at the beginning of his spiel at the beginning, then it may be not that big a deal, other than the president will in the beginning of his term or her term or their term, fire everyone, clean house or not clean house, just depending, and then allow them to do what they want as long as they don't get too out of line. So it may have not really much of an effect. On the other hand, what if I don't think this is going to happen, but what if the court decides not to sever? Says, yeah, this is unconstitutional and we're not going to sever, and then sends it back to Congress. That's really interesting, because it means a lot of agencies, and by the way, there's a severability clause for the NLRA, so this is extremely unlikely, but it could do it. Or what if the court says, because there's a severability clause, we are going to sever, but if there's no severability clause, these other agencies, no way. And I don't know how many agencies that would affect. Well, then we could see, again, this is the parade of horribles, but we could see the dismantling of the administrative state. I don't think that's likely. I agree with Aaron that what's more likely is severability. And so it's more going to be about the president being able to fire and hire, fire at will. Hiring's a little bit harder because the president needs the advice and consent of the Senate. Yeah. And we know the NLRB, for example, has gone quorumless many, many times in the last 2 decades.
Okay. Aaron, your thoughts?
I mean, I agree with almost everything Professor LaFosso said. I think, just thinking about second order effects, it's what, I'm not thinking so much about the heads of agencies, because that question is going to be decided either in SpaceX or in the case like in Wilcox or in Harris, which deals with the MSPB members removal, or Trump also fired members of the FTC. So it will be decided in one of those cases for principal officers. I'm more interested in how the court handles inferior officers, right? Because if you get rid of tenure protections for the NLRB and MSPB, ALJs are no longer shielded by multiple layers. So one, is there an argument that you can still remove an ALJ? And I think so, under Morrison and Celia law, which say that the president has the ability to move an inferior officer who has policymaking or administrative authority. And what does that open up in order for a president to be able to control the bureaucracy? And what does that mean for our civil service laws? Because there's lots of other officials at the NLRB who engage in policymaking or administrative authority. And I'm thinking of the NLRB, the way it's set up is it has a bunch of regional directors. It's like little fiefdoms where the regional directors acts as like a U.S. attorney, where they can bring cases, they conduct elections. They really exercise the power of both the board and the general counsel, and they're only responsible to them, but they're considered to be senior executive service civil servants, right? So could the president fire a regional director under one of these theories? Well, possibly. So I think as long as you have a president in power who wants to push on questions of what kind of control they have over their administration, I think these are going to be far more interesting in administrative law questions than for everyday labor law.
I want to add some, that's a really interesting point. Peter Robb, as you may recall, actually tried to have greater control over the regional directors. So perhaps if the general counsel were to much greater control, we wouldn't see that. But with a president that does like to push, I always call President Trump the gift that keeps giving to the academic community, because we get to teach all these cutting edge issues of labor law, constitutional law, administrative law. So, but I could see that very well happening. I hadn't thought of that. So I think that's a great point.
I realize we've been discussing the possibilities of outcomes, legal outcomes, but let me ask the two of you, based on a question we just received, how will Congress play in this, since they seem to be so flummoxed in dealing with the NLRB, its structure and its appointees? When a decision does arrive, it doesn't seem like they would be in a position to offer a constructive solution, but I'd be curious of your all's thoughts. Aaron?
I don't know how Congress would play in this. Obviously, if Congress was worried about a more an NLRB that's politically accountable to the president, and they're worried about what kind of decisions they make, they could amend the National Labor Relations Act in substantive ways in order to restrain the president's ability to make clear the NLRA is a pretty general act, right? It has its election section, Section 9. It has the rights granted in Section 7, and it has a bunch of prohibitions on restraint and coercion in Section 8, as well as a few others. But it's a very general statute, and because it's so general, you get more policy oscillation. So if you're worried about policy oscillation, I think the only way is for Congress to reassert its authority and create an NLRA or pass amendments to the NLRA that are far more clear and strict in what kind of deference the president gets in interpreting and enforcing the law.
Yeah, and some people think that policy oscillation might be dampened with the overturning of Chevron deference, but of course that's going to depend on what the post-Chevron world looks like in terms of deference, whether it's de novo, whether it's some other form of Skidmore deference, whether it's going to be bifurcated into some way. So I think it's really hard to know what Congress is going to do, though. And I think you're right, Pat, when you said Congress hasn't really responded many times and it hasn't been able to amend the act in any significant way since
47.
I could even say 1947, but certainly in the 1950s. And yes, there's been a couple of amendments in the 70s, but they really were not significant. And so that's a long time. And I think that there's just a strong ideological divide, and no one wants to get rid of the act, but no one wants to no one wants to keep it, no one wants to get rid of it. It's kind of dysfunctional, or it can get dysfunctional. And so until we start to kind of think, okay, what is the purpose of a Congress? Is in a pluralist society, it means that we accommodate each other, that no one is a winner, no one's a loser all the time, that we have to actually compromise. Until we get back on that track, and no one wants to compromise, but we're not going to be able to solve our problems. And I think we may lose the lessons of the New Deal is, well, what happened when workers were feeling the crunch, there was uprisings. That's what I'm worried about. I'm an institutionalist. I'm very concerned that if we don't have a way for there to be labor disputes to be resolved, and there's repression of workers and their associations, then we're going to see more violence. And that was why Republicans came on board with progressives to have the NLRA. So I really wish that somehow we could figure this out together, but that's Congress's job, and I don't see that happening right now.
Well, but keep in mind the Republicans and the Democrats came together in the Taft-Hartley Act to override Truman's veto of it, to lay the groundwork that we're still living with. And is sort of agreed upon by the parties that no one wants to give an inch here. Well, we're getting close to the hour. How about the final 60 seconds or so from each of you? Start with Aaron.
In closing, I would just say, when you think about these cases, I always just think about there's three branches of government. And if it's not acting in a legislative manner, and it's not acting in the judicial manner with a life tenure, and it's in the executive branch, it is executive power. And if it is executive power, they have to be responsible and politically accountable to the president. And so I think the decisions in these cases were right, and it will lead to more political accountability and a more responsive government.
Okay. Professor, your thoughts?
I would just say that presidential accountability doesn't necessarily mean that every officer who's inferior to the president needs to be on a leash. So I would say maybe there's some room here for to have some independence in order to have more due process.
Okay. Well, I guess accountability is the buzzword for today, and I want to thank those of you who participated online. Thank you for your questions and your time. And I want to thank both Aaron and the professor for their insights. And of course, thank you to the Federalist Society for putting this all together. Sarah, anything else you want to remind us about?
Yes, thank you. I just wanted to say, on behalf of the Federalist Society, thank you so much to Professor Lofaso and Mr. Solemn for speaking with us today, and for Mr. Pizzella for moderating. We're so grateful for your time and expertise on this important topic. Thank you to our audience for joining us. We really appreciate your participation. You can also stay up to date with other announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.